next class, I don't have to do any work. You get to do all the work. So that's my favorite thing of the entire course. Marking exams, not so much. Okay, so today's class, let's see how it unfolds. Depending on where we are, at about 10-ish, if not sooner, I'm just going to start talking about the assignment and exams and things like that. So we'll make sure we cover that substantive content aside. Let's see how far we get. And today's class is structured intentionally so that the tail end is, you can read it on your own. It's not a particularly onerous subject like some of the earlier days. So that's the plan for today, and we'll talk about all of this stuff. Okay, so I'll make sure we have time for all of this stuff. Okay, first things first. Who's our star lawyer of the day on the screen?
Is that Glenn Close from Damages?
That is Glenn Close from Damages. What kind of lawyer is she?
Horrible.
Okay. Who else has seen this show? Who else has seen this show? Is it on? It's not even on Netflix or anything anymore.
It was.
Was it?
Mhm.
Okay. So what kind of lawyer is she? Since you're the only one that's seen it, you know.
Well, she's evil, she's ruthless, she gets results, but she does it by killing people and, anything else that stands in her way, she steps on.
Anything to win, right? So she's the kind of lawyer from our ethical perspective who will do anything to win, to the extreme, including killing people, right? So she is of the extreme version of which sort of theoretical approach that we covered in class. Which one is she?
Devil's advocate?
Yeah. She's like the extreme around sort of notion of anything for her client, but not even so much for her client, almost for her own, for her own reputation, her own ego, and her own success record, right? So Damages is the show, if you can find it somewhere. It's really good, but it's really boring. Okay, that's our ethical or unethical of the day. I need a reader for our last days. It's not even a joke. Inspiration. Nice and loud. You don't have to worry about all this stuff. Just there. Nice and loud.
And since your life seems almost too much to handle, when 24 hours in a day is not enough,
You would just go louder.
remember Mayor Lazy,
Come on down here.
John, and
Come here.
2 cups
Come on.
of coffee.
Come down here. This is very inspirational. Go on down here. Nice and loud. Please just start over again because I'm not sure. Okay, go.
Where this goes. When things in your life seems almost too much to handle, and 24 hours in a day is not enough, remember the Mayor Lays jar and 2 cups of coffee.
No, the whole thing.
A professor stood before his philosophy class and has some items in front of him when the class began. Witness he picked up very large and empty mayonnaise jar and filled with golf balls. He then asked the students if the jar were full. They agreed that it was. The professor then picked up a box of pebbles and poured it into the jar. It shook the jar lightly. The pebbles rolled into the open area between the golf balls. He then asked the students again if the jar was full. They agreed it was. The professor then picked up a box of sand and poured it into the jar. Of course, the sand filled up everything else. He asked once more if the jar was full. The students responded with unanimous yes. The professor then produced 2 cups of coffee from under the table and poured the entire the contents into the jar, effectively filling the empty space between the sand. The students laughed. Now, said the professor, I want you to recognize that this jar represents your life. The golf ball are the important things: God, family, children, health, friends, and the favorite passions. Since that if everything else was lost and only these remained, your life would still be full. The pebbles are the things that matters, like the job, house, and car. The sand is everything else. A small step is sand. If you put the sands into the jar first, there's no room for the pebbles and the golf ball. The same goes for life. If you spend all your time and energy on the small stuff, you will never have room for things that are important to you. I told them. So pay attention to the things that are critical to your happiness. Worship with your family, play with your children, take your partner out to dinner, spend time with good friends. There will always be time to clean the house and fix the dripping tap. Take care of golf ball first. The thing that really matters. Set your priority. The rest is just set. As for the coffee, it just goes to show you that no matter how full your life may seem, there is always room for a cup of coffee with a friend.
Oh, thank you. Very inspirational. Okay, thank you very much. Okay. Today we are, what are we talking about today? No way, man, that's inspiration before your exam. Okay, you need inspiration before your exam. Okay, today we're talking about, there's my disclaimer, today we're talking about government lawyers and subsequently class actions, ethics, and counseling. So the last day, I think, we talked about criminal law as a specific area. So ethics, we know you're going to carry this with you like a ball and chain, no matter what area you practice in, but we also know that some areas of law can be ethically challenging in their own unique way. So government lawyers. Government lawyers are the lawyers that work, they're basically in-house, like an in-house counsel, where the employer, instead of being a corporation, is the government, right? So what are some of the issues? Well, some of the issues are that it's in the public eye, so that it's reflective of the government of the day. And remember, what happens in most cases is the staff and the lawyers of any government, the government may change, the ruling party or the leader of the party or the individual or what have you, but the people that work sort of, you know, the cogs in the wheel that work every day tend to be the same people. So it doesn't really matter what your party affiliation is. The government's the government. So one of the key aspects of being in the public eye is no conflicts of interest. You must declare any potential conflicts. Information acquired as part of holding public office must remain confidential even after public office has ended. So that confidentiality notion that we talked about way back when in our first couple of classes, that is highlighted here because you have access to lots of private and confidential information. And just like with a law firm, the entire department can be closed. Just because you work for one project where you have access to confidential information, the rest of the department is also closed with that same responsibility. Is there a higher standard if you work as a government lawyer? So, in Everton v. Ontario, so this is a case from, give me a page reference. 599. Page 599. So what happens is, this is a case from 1992. And so what happens is, there's a mental health facility hearing to discuss capacity and so forth. And the lawyer for the Attorney General's office, so the government lawyer, right, the person representing the government in the action as between the individual, Mr. Everington, and the lawyer for the government of Ontario walks up to the individual and he says, can we talk? Let's have a little talk. And the patient's lawyer, so the patient is represented, which is not unusual, right? Because this might be a mental health issue. Should you be discharged? Are there conditions and so forth? So this person has representation. But that person isn't present when the government lawyer approaches him. The patient's lawyer wants that lawyer from the AG's office. The application is successful because of a perception of unfairness was too strong. And this case says not because there's a higher standard for government lawyers, but the perception is unacceptable for the public nature of the lawyer's job. And the court finds an obvious appearance of compulsion. So the government lawyer goes to the institution where the individual is being held and says, can we talk? Takes the individual into a private room, closes the door. And the guy's wearing fuzzy slippers, right? With the gown, with the ribbons in the back, like he's a patient here. And the evidence is, the government lawyer says, tomorrow you're being examined for discovery. It's a civil matter, right? Don't worry, it'll be okay. So the evidence reflects that the government lawyer actually said something that was innocuous and arguably helpful. Added some comfort, made the person feel more relaxed and comfortable. Doesn't matter. It doesn't matter, right? Because the patient is under custodian compulsion to meet with his opponent, the Crown, which is the government lawyer, absent his own counsel. So he's locked in this place, waiting for the hearing to see if he can be sprung or not. So there's a compulsion there. The meeting's in a closed room, hidden from the public, no transcript. So all we have is the evidence of what people say. We don't have a transcript of it. And the Crown's innocent version, it'll be okay, just want to make you feel comfortable, is irrelevant. Even though that version is preferred by the court as being probably more likely, doesn't matter. It's the inevitable result that such a meeting will produce different versions, and that is the mischief to be avoided. Is there a higher standard? Hands up. Who thinks if you represent the government of the day, which all of us voted for to elect and represent us in the House of Commons, and you're a lawyer working in that department, do you have a higher standard than a lawyer working for a private client? Hands up, yes, higher standard. Hands up, nope, same standard for all lawyers. Okay, someone tell me why you think it's a higher standard.
All right, so, I think the textbook, there's an argument that talks about the Attorney General, and it's the Attorney General that actually appoints you to represent the Attorney General in cases, and because you're the eye of the Attorney General, you are supposed to, in some way, have more ethical value, because people will expect you from your personal
Right, more than a private.
So they're representing the public, not just the public.
You represent all of us, right? Those of you who say no higher standard, lawyers are lawyers. Somebody raise your hand who said that. Who wants to comment? G. June, I'm sorry. It's right there. It says June. Okay, go ahead.
So I would say, all of us lawyers should have the same standard. And if you make one higher standard than the other, it takes away from the normal lawyer to say, okay, you are not that important, you can do whatever. You could walk the line, the gray line sometimes.
Because your client is just Joe Schlub, right, that walked in off the street, as opposed to your client is who we all voted to be in power, right, Joe?
I think something that needs to be factored into whether it's same standard or higher standard is to keep in mind that the government lawyers have a whole lot of resources that Joe Q. Schlub doesn't have. Not only resources but power. So I think it makes it a more delicate balancing act, especially when you look at that third point on the PowerPoint there about protecting it, from the inside.
Right? Okay, so rule of law, number one, you all have to respect that. But this is, so all of these points, by the way, it's an open debate. Like there's no final answer, right? There are people that take this position, there are people that they take this position, and it's an ongoing debate. I wouldn't say it's raging, but it's a debate. But remember that notion of what the Crown attorney, so a government lawyer can be a Crown, but it can be civil too, right? Crown office, civil, Crown office, criminal. Remember we talked about all the resources that the Crown has versus poor little defendant lawyer? Same concept, right? Even though it's not a criminal matter, the AG's office, Crown Law Civil, has all these powers, resources, staffing, and so forth. We still have that notion of that effect. So is there a higher standard? Maybe, maybe not. It's an open debate. And yes, important to protect the rule of law from the inside because you're on the inside. You're on that side of the wall. to ensure that you're considering broader issues, not just interpretation of what the client wants to hear. We mentioned torture memos last day. We'll look at torture memos a little bit more shortly. The other sort of aspect of a government lawyer is this notion of fair deeds. Now, to whoever's point it was, we all have obligations of fair deeds. But the argument is that when you act for a private individual, you're acting for one person, one person's interest, or a corporation, doesn't matter, for one client's interest, as opposed to government lawyers who are working in the interest of all of us, of you, and you, and you, and me, and everybody in this class, everybody in this country, and or in this province, in this case. So, for example, there's a public interest responsibility. That's the notion, right? For example, in criminal law, we looked at that last time, duties of disclosure. Objective is to find the truth, bring all the evidence forward, not just to win. And the government owes an outcome to its citizens. They have an obligation, the theory is, to all of us for a fair outcome, not just to win because the other side is a self-rep, or maybe can't afford a lawyer, or maybe what have you. So the notion is public interest, optics, public exposure, fair dealing. And you need to moderate the zealous advocate approach to interactions with its citizens, because the clients are us. The clients are us. That's the notion. So, let me see if I can change references. Yeah, so everything I think I said was page 599. That's the case we just saw with the guy in the institution. Page 621. You know what? Let's see what's on page 621. Let's see what's there about this notion of prior standard. Let's see. Can I get a reader? Can I get a hallelujah? Can I get a reader? 621. What does it say? 621. Well, I don't need to read it. 621 just has a reference to, you can read it on your own. It has to do with the Residential Schools Truth and Reconciliation Commission and the government's role in that process, and we touched on that briefly in the context of Tony Merchant and class actions, right? Okay, so let's move on to torture memos. Torture memos. That sounds awful. What's a torture memo?
I don't believe that's something to do with or power.
Okay. So here's what happens. Yes, that's the notion, right? So here's what happens. It's actually in the context of the United States in, oh gosh, what year? I think Bush 2, Bush whatever, and Guantanamo Bay. Right?
I know which one.
Right? So I think it's sort of post 9/11 kind of thing, many years post 9/11, and what happens is a number of people are, collected, arrested, and put in Guantanamo Bay. And so the U.S. administration is trying to get at the bottom of what happened on 9/11 and who's involved and who can sweep information from. And what happens is the U.S. government provides legal advice. Now it's a U.S. context, but notionally, same government lawyers working for the U.S. government. And the government lawyers provide legal advice to interrogation techniques. Interrogation techniques is a nice soft term for compelling information from people like waterboarding and all that horrible stuff. So what we have is the government lawyers are asked. They're asked, how far can we go with these interrogation techniques? How far can we go and still be on side? We want your legal opinion, government lawyers who work for us, by the way we signed your paychecks, right? And it's an example of legal interpretation used to authorize state powers. Adam Dodick, a well-respected, very prolific ethics writer, Canadian, argues the government lawyers use the law as the handmaiden of unconscionable abuse. That's his terminology, and that's what he says they're doing. So here's argues the government lawyers spun their legal advice because they knew it was what the client wanted to hear, and describes the memos as loony and legal formalism run amok by use of a phrase in one statute to interpret meaning in another statute. So reading between the lines, the government says to its lawyers, we want to question the people in Guantanamo Bay, we want to use various techniques, we want to be on side legally. And the argument is that the government lawyers, well, they know what the client wants. The client wants the okay. The client wants the rubber stamp to say, yes, you can use waterboarding and you can use what have you. You can use all these techniques. And they do it in a way by legal formalism run amok, is they take the law and they write a memo, the torture memos, which says, yes, client, you can do what you want. You can do these interrogation techniques. But the way they do it is they take the definition of a term from one statute, apply it to a different statute, doesn't have that definition, and they write this memo conflating different kinds of legal precedents in order to get the result they want. Now, you gotta be smart, no problem, right? This is not an easy task, but it can be done. It is done in this case. And let's see what David Luban has to say about it. Now I do need a reader. Page 462. 462. Tales of Terror, Lessons for Lawyers from the War on Terrorism, and so forth. And reader. Anyone pen it? Do you have it?
Yeah,
You can read? Okay. Yeah, of course you can. So it's this section here, excerpt from David Luban's article. Yeah, nice enough.
A dramatic example of ethical obligation related to the advice a lawyer gives to his or her client arose in the context of the United States government's dealing with detainees following the September 11, 2001 terrorist attack. The government wanted to interrogate the detainees in as forceful and effective a way as possible without violating international law related to torture. It sought opinion from senior lawyers in the Office of Legal Counsel of Justice Department. These opinions concluded that interrogative techniques did not amount to torture unless they posed a threat of organ failure to the detainee. The opinions were provided to a client that presumably wanted as much leeway as possible in obtaining information from the detainees in order to prevent further terrorist attacks and to capture the perpetrators of terrorist attacks. The opinions have since been discredited as having significantly overreached the legitimate interpretation of what constitutes torture, and they were ultimately disavowed by the Office of Legal Counsel in 2009. David Luban was one of the most vocal critics of these torture measures, partly because of their content, but also because in his view, the lawyers who provided their advice to their client failed in their ethical duties as counselors and advisors.
Thank you. So we have that sense of what the client wants to hear. They know what the client wants to hear. They spin their advice so it's satisfied what the client wants to hear, but it's an abdication of their ethical responsibilities. So this is a warning. This is a situation for all of us to keep in mind. And I mean, the chances are of you being counseled to post 9/11. I don't know, it could happen. I don't know it. But just take it in the normal context of a regular client that wants a particular outcome, and you're a government lawyer, and they want a particular outcome, and it's your obligation, according to David Luban and many other ethical writers, that it is inappropriate and unethical ensure no conflicts, and must declare potential conflicts. Okay. So, in a less dramatic example, the government works very often with tax issues. You know, some people think it's boring, but some people don't. And so in General Motors v. Canada in 2008, in this case, the question was the application of the GST to investment management services. And in this case, do I have a page reference? Is this me open? Do you have a page reference or don't have it? No problem. If it is, you can find it. And this has to do with the ethical obligations in terms of pleading. So it's not nearly as dramatic or colorful. But if the government is pleads something in their written pleadings in a transaction with, in this case, General Motors, that the pleading has to, even if the pleading relies on assumption, then you don't have to prove it if it's reasonable. The assumption must be found to be proper. Government lawyers coach the witness, shouldn't have pleaded, should have amended the pleadings, and the assumptions in pleadings must be stated fairly honestly and accurately. So it's a bit more of a paperwork kind of an issue where you're alleging something, you're writing and pleading, you're standing in front of the court, alleging certain facts or law and so forth. And this case is a warning not of the extreme kind, but more of the day-to-day kind, that the assumptions must be fair, honest, and accurately stated. And this goes back to that notion of representing the public, being fair, being in the public eye, and having a public interest obligation to discharge.
6:20.
Thank you. 6:20. Okay. Yeah, written. Class action. So we touched on class actions briefly before. So class actions are an area of work where your client is one representative, the named individual, but behind that client is the class of people, all of whom have whatever commonalities or whatever similar interests, backgrounds, or causes of action, and so forth. So you really have a group of clients as opposed to just one. And the concern is the potential and often genuine antagonism among the class members and representative plaintiffs. So what happens is, because you've got one representative plaintiff, that person is named in the pleadings, behind that person is everybody else. And you know how people are. Someone's going to disagree, someone's going to want to branch off, someone wants more money, someone's happy to settle. So you're going to have this kind of potential for disagreement and discontent in the larger group. And so when dealing with class actions, the counsel's obligation to the class representative are no different than normal lawyer and client. So just because you have one individual with whom you are dealing as the named or the lead plaintiff, your obligations are the same to everybody in the class. It's not very, there's not a lot of guidance. It's not very clear. It's a very complicated area, but the point is to be alert to the pockets of different kinds of interests and concerns that your class may have. And so if you take on that kind of work, it can be very lucrative and it can be very interesting, but it also can be a lot of work just managing the client, or the clients, or the group, or the class. And you have the other complicating factors, right? Every single individual in the class has an expectation of confidentiality. So we may meet separately, confidentiality. We may meet separately, we may meet separately. All confidential, and yet at the same time you're also one collective group. So that can get very complicated and nuanced. There's also a requirement to explain to the representative plaintiff that acting for more than just one individual. So although you have, remember Mr. What was his name? The farmer, class action farmer against CNR. What was his name? Huh? Remember the farmer, right? Yeah. So representative person, plaintiff, to say, well, I'm not just representing your interest. And sometimes it's not a, it's not a straightforward concept, especially for an individual who thinks, well, I'm the guy whose name is on the documents and I'm the guy that you're representing. And settlement. So I believe the vast majority of class action suits settle. They take years, but they settle. And so what happens is you also have to be concerned about conflicts of interest and settlement versus going to a hearing. You've got the litigation risk. You may want to settle. You may want to go to a 6-month trial because that's a lot of billing that you can do. And therefore, assuming you're successful, take a percentage of it as a class action counsel. But in a settlement, you get your class action percentage payment from the settlement immediately. So if there's a conflict between those two interests, it may be advisable to have ILA, independent legal advice, for the plaintiff. So the class action lawsuit has to be certified. What does that mean? What does certification mean?
The court is the entity that certifies, accepts.
Approves the class. Anything else?
Basically, use a green light. Go ahead.
Yeah. So there's this preliminary step, and it can be quite time intensive and work intensive to get the class certified as an approved or a sanctioned class action proceeding. So the ethical obligations to class members before class certification, not as clear, still problematic, but it hasn't been blessed. It hasn't been validated or approved by the court, so that's pre-certification. At pre-certification, you can't treat the class members as non-clients just because they haven't been certified. They still have all those obligations, right? Loyalty and duty and confidentiality and competence and maybe privilege, depends on the situation. Better to treat them as potential or quasi-clients, so there are some minimal obligations, competency applicant, and confidentiality. Post-certification, now your client has been, like, they've all been scooped up and put to a bucket, and now they've been certified, and your obligations, in theory, might be a little bit higher. You still have a primary obligation to the class representative, who generally, subject to conflicts, generally is the talking head. That's the person talking about what the instructions are. However, not your only obligation, the rest of the class is as well. Should be aware that may be potential conflicts among class members. Oh yeah, and then some classes can form with their own lawyers. So not only is your plaintiff complaining, but this group over here, they want to settle and you all want to go to hearing, go to trial, they got their own lawyers, and now you've got fractions. Now you're breaking out into different groups. Okay. Do I have a page reference for Western Canada? Someone let me know if this is I didn't write it down, so I can. But the case is the 2001 case. Aggregation of similar individual actions, class actions, serve judicial economy, right? We talked about this way back when. We talked about Tony Merchant and the class actions in the residential schools. The benefits and the aspects of class actions that contribute to efficiency are you won't have 45 different statements of claim on the same issue. Court resources, time, availability of court staff, 45 lawyers. Well, they might like that. But it's judicial economy, avoiding unnecessary duplication, right? In fact, finding a legal analysis because you all have the same, you have some commonality. So we're saving repetitive action, and in particular, who likes that is the defendant, right? The defendant doesn't have to answer 55 different statements of claim, but it's just one. The efficiencies generate they free up judicial resources, makes sense, right? That can be used elsewhere, reduce the costs of litigation, and you don't need the defendant defend once and not over and over on your book? Okay. Alright, fixed litigation costs. Fixed litigation costs divided over a number of plaintiffs, it's an easier financial burden for all individuals, and economical prosecution of claims that would otherwise be too costly to prosecute individually, so whereas you may not have the resources to be a plaintiff on your own as a class, then you spread the pain, you spread the cost and pain. Without class action, doors of justice remain closed to some plaintiffs. However strong their claims are, sharing costs ensures injuries are not left unremedied. And that goes back to an earlier class on access to justice, right? This was another example of a way in which an individual who maybe otherwise would be shut out has access to justice in this collective group. We're going to be out of here. This is great. Okay, ethics and counseling. So what are we talking about here? So ethics and counseling. Again, referencing back to our earlier notions, you're not just a lawyer when you're an advocate. You're not just a lawyer when you're in court. You're not just a lawyer when you are representing a client. You're also a lawyer when you're counseling or negotiating. And counseling is giving advice to someone who may or may not then decide to take further steps or further actions or take additional legal recourse. But counseling can be simply giving advice on the state of the law. If a student says, "Have I even got a case here? What's the likelihood of success?" You may simply do that task. You may give opinions on how the law intersects with the client's given facts. And you may also give advice as to how to proceed. Let's look at the model code, 3.2-2. Remember, 3 is our great big fat nice rule that has a lot of the substantive aspects to it. 3.2-2. And so there it is. You must be honest. You must be candid. You must inform the client of all information known that may affect the interests of the client in that matter. You are speaking to the intersection of what the law is and their given set of facts, which, ironically, is often how an exam goes too. You have the law, you have the facts, you apply the two, and you see what comes out. Let's have a reader for the commentaries. Commentaries, good stuff in the commentaries. Good stuff in the commentaries. Let's have a reader for commentaries 1, 2, and 3 of 3.2-2.
A lawyer should disclose to the.
Sorry, who? No, I didn't call.
So, okay, you got some?
Nope, not yet. Looking for an in. 1, 2, and 3.
The lawyer should disclose to the client all circumstances of lawyer's relation to the parties and interests in connection with the matter, if any that might influence whether the client selects or continues to retain the lawyer. A lawyer's duty to a client who seeks legal advice is to give the client a competent opinion based on a sufficient knowledge of the relevant facts, an adequate consideration of the applicable law, and the lawyer's own experience and expertise. The advice must be open and undisguised and must clearly disclose what the lawyer honestly thinks about the merits and probable results. Occasionally, a lawyer must be firm with the client. Firmness without rudeness is not a violation of the rule. In communicating with the client, the lawyer may disagree with the client's perspective or may have concerns about the client's position on a matter and may give advice that will not please the client. This may legitimately require firm and animated discussion with the client.
Okay, thank you. So remember, you can take your model code into the exam. Model code commentaries, you must, I suggest father's behavior was inappropriate. There was an existing court order, presumably, that said the father will see the kids on the weekend, and you know the kids live with them or what have you. Doesn't matter. There was an existing order, and Sussman says, no, don't worry about the order. Withhold access. He writes a letter advising father's lawyer that they're going to apply for a temporary restraining order, but he never did. So in terms of, remember we had the notion of if the phone rings and I see your name on the call display, and I think, oh man, this is going to be a nightmare. I don't need to deal with this nonsense today. Or if I see your name and I think, oh, we're going to work this out, this is going to be good. It's about your reputation, it's about your demeanor, it's about how you treat people, it's how you behave, it's how you reflect in terms of your fairness and your collegiality. So when a person writes something in a letter that says, I'm going to apply for a temporary restraining order, but never does, how does that, but never does, so how does that reflect on the lawyer making that, and I'll call it a threat to bring it to the court? How does that reflect? So, I don't know how to vote on this. Hands up. It's being tough. Okay? Hands up. If you ain't gonna do it, don't threaten it. Okay. What's your position on? That's an approach. It may be tough. It may be, loud, but it's okay. What's your thinking on it?
Sure, I think it's okay.
You don't think it's okay?
I don't think it's okay because it's kind of tactic. It seems tactic.
You might.
So I think it's very okay because lawyers do this all the time. Think about it. Assuming you're handling, let's say, recovery suit like funds recovery, okay? You threaten the person that, hey, I'm going to bring up the lawsuit against you. You don't pay off this money as supposed to. It's very normal, yeah. And most times they don't pay up, but you don't bring up the suit, but you still find a way to settle and resolve the issue. Fine. So I think it's totally okay.
Okay, and who disagrees with that? Kasim.
Well, basically, there's no point in
Go ahead.
giving empty threats, right? If you gotta do, you gotta do something. Just don't shoot in the dark. That's what I.
Because, what's the thinking behind that?
Because being a lawyer, you should only act on. You should do what you're gonna do. And empty threats don't make you a good lawyer.
Okay. Who else had it? Okay, yeah.
It's possible that making an empty threat could give rise to wasting of resources. What I mean by that is if I threaten you that I'm going to do a restraining order, whether I do it or not, maybe you start spending, or your lawyer starts spending time preparing for that and thinking about that, and oh my God, how are we going to deal with this? And then it's all for naught. It never happens. So it flushes resources down the toilet.
And the next time the phone rings and I see your name, this dude threatens all the time. I don't know.
She summed up what I wanted to say.
Did she?
Sorry.
Did you have a comment?
Same as what Kasim said.
Yeah.
So I mean, it's against the code as well. So I mean, threatening. So yeah.
Yes, that's a good point. Okay. Can we find that? Yeah, go ahead, Mike. It's true. It's a little bit nuanced, but go ahead, let's find it, let's look at it. But, so the answer is, it depends, right? It depends, because it may be, do you have a comment?
No, I'm just saying that this is not really threatening. Like you're just saying that I'm going to do this. So it's still there's something you said about writing, not like yeah, bluff. So it's like so they can make an action. So it's not like you're really you're kind of forcing them to do something, but it's not really
Yeah, right. So the answer is it depends, right? The answer is it depends. Sometimes it'll get you to a settlement. Sometimes it'll get you to a conclusion. Sometimes it'll get the guy to think or the person to think about it more seriously. Sometimes it's a waste of resources. And you have to make that call, right? You have to make that decision. I mean, there's some lawyers that take the position that if I threaten I'm going to issue a statement, I'm going to do it. So you better have those instructions first before you say you're going to do it, and then go ahead and do it. But I'm not going to threaten unless I'm actually going to do it. So this case is critical of this, and the word threat may not be this suggestion that something's going to happen was not appropriate in this case. Now remember, it's all contextual, it all depends, because family law, we're a lawyer may not go to a child's new bike, like that kind of thing, right? So it's all contextual, it always depends. But the Law Society, in this case, condemns the behavior of Mr. Sussman because they say it brings administration of justice into disrepute. You never want that. It undermines the court's effectiveness and encourages law of the jungle. Law of the jungle. What's that song?
Welcome to the jungle by Guns N'
What?
Roses.
What?
Welcome to the jungle by
Welcome
Guns
to
N'
the
Roses.
jungle. Yeah, someone should play that in the background when we talk about this. And so the consequence is a suspension for 1 month. Did you find this?
Yeah, 3.2-5.
Okay. Hold your thought. Can we go there? Can you please read 3.2-5?
A lawyer must not, in an attempt to gain a benefit for a client to threaten or advise a client to threaten, to initiate or proceed with a criminal or quasi-criminal charge, or to make a complaint to a regulatory authority.
And commentary one.
It is an abuse of the court or regulatory authority's process to threaten to make or advance a complaint in order to secure the satisfaction of a private grievance. Even if a client has a legitimate entitlement to be paid monies, threats to take criminal or quasi-criminal actions are not appropriate. It is not improper, however, to notify the appropriate authority of criminal or quasi-criminal activities while also taking steps through the civil system. Nor is it improper for a lawyer to request that another lawyer comply with an undertaking or trust conditions or professional obligation of his being reported to the society. The impropriety stems from threatening to use or actually using criminal or quasi-criminal proceedings to gain a civil advantage.
No. Sorry. So that was 3.2-5. And the heading is threatening criminal or regulatory proceedings. So it's like it's along the same line. It's not identical, right, to this. And then you have the corollary, right? You have the partner to that, which is 3.2-6, inducement for withdrawal of criminal regulatory proceedings. You also can't. Well, let's see what it says. Who wants to read 3.2-6? So this is where 3.2-5 is threatening criminal or regulatory. 3.2-6 is inducement for withdrawal of regulatory. So let's have a reader for that. Okay, Andy.
A lawyer must not give or offer to give or advise an accused or any other person to give or offer to give any valuable consideration to another person in exchange for influencing the crown or a regulatory authority's conduct of a criminal or quasi-criminal charge or a complaint unless the lawyer obtains the consent of the crown or the regulatory authority to enter into such discussions. Accept or offer to accept or advise a person to accept or offer to accept any valuable consideration in exchange for influencing the crown or a regulatory authority's conduct of a criminal or quasi-criminal charge or a complaint unless the lawyer obtains the consent of the crown or regulatory authority to enter such discussions, or wrongfully influence any person to prevent the crown or regulatory authority from proceeding with charges or a complaint, or to cause a crown or regulatory authority to withdraw the complaint or state charges in a criminal or quasi-criminal proceeding. Regulatory authority includes professional and other regulatory bodies. A lawyer for an accused or potential accused must never influence a complainant or potential complainant not to communicate or cooperate with the crown. However, this rule does not prevent a lawyer for an accused or potential accused from communicating with a complainant or potential complainant to obtain factual information, arrange for restitution or an apology from an accused, or defend or settle any civil matters between the accused and the complainant.
Thank you. So what we have there is in the commentary and in the rules, guidance. Guidance. You can take them to your situation. You can read and say, I think I'm on side, I think I'm off side, what have you. And make those decisions, make those calls. Always contextual, fact specific, fact dependent, but we have some guidance there. And when you're faced with that kind of a situation, you can read your model code, you can read the Ontario Rules of Procedure, not procedure, of practice. rules, professional conduct, RPC. Okay. So we're in the context of counseling or advising clients what to do, some things you can't advise clients to do, and the subsequent examples of what you should not do. In counseling advice, who then argues that the lawyer should be given independent advice, not scaled to what the client wants to hear. The same notion, not just giving advice to what the client wants to hear in terms of what outcome they want. When you're advocating for a client, you can be more one-sided, is because you're standing up, you're advocating the client's interest, there's someone else on the other side that's going to bring forth the other side of the argument. So the difference between those two roles that you play as a lawyer are distinct. The other hat you could wear is as a negotiator, and sometimes you are trying to come to a resolution, you're trying to come to some kind of conclusion, you're trying to get some kind of agreement, you're trying to get people on board to a common goal, a common outcome. And it could be deal making, dealing with outside suppliers, divorce settlement as a collaborative law lawyer, labor lawyer, plea bargains, you're engaged. So there's times when you're not advocating, you're not counseling, you're just trying to negotiate to get some kind of common outcome. And this harkens back to our notions of differing views of lawyers, right? Representing the client's interests, even if ridiculous, that's the zealous advocate model. We know that from Lord Brown. Interests of other parties to the client and the client's interests, ethical and public interests, negotiator as professional model, and that's the more broad notional concept of considering other interests in the larger picture. So settlement, we know that we have to encourage settlement. We have a clear obligation to encourage clients to settle, and that is found at 3.2-4, encouraging compromise or settlement. 3.2-4. So see, please are all the good and neat stuff. 3.2-4. Yeah. And it just says you must advise and encourage settlement and compromise wherever possible on a reasonable basis. For the reasons we know, right? Saves time, money, aggravation. It can be a win-win, lose-lose. A really good settlement is where no one's happy because everybody's given something up to come to a final conclusion and reach a goal. Lawyers must have instructions for settlement discussions before you go in, and negotiations are generally without prejudice. So once you reach a settlement, the court has to approve it. You can't just say, oh, we're done, thank you very much, you pay me, and I'm out of here. The courts may refuse a settlement if counsel did not have authority to settle, misapprehension by the lawyer of the client's instructions, fraud, or if there's an issue to be tried where a settlement would be inappropriate or disadvantage one party or the other. Did I already ask you this, where your client says, I want you to settle at $50,000, Mr. Tucker?
Yeah.
And you go in, you say, my client will not take a penny less than $60,000, remember that?
Yeah.
And so you've got that concept of what are your instructions, because if the other lawyer says, oh, $60,000, no way, let's go, and your client finds out, I didn't say 60, I said 50, so then the law society calls you, right? So you need to have instructions, and you need to have the settlement approved by the court. And this is sort of a theoretical background, is some of the theories behind how writers have described or explained motivating factors for settlement. And so you can read those. They're called impulses. Integrity. So we know integrity. Rule 2, our whole entire rule. The whole entire rule. The whole entire rule. It's 2 pages. It's all about integrity. It devotes an entire rule just to integrity. So when when you're negotiating a settlement, you have different strategies, you might have different philosophies as to how you're going to get to a particular outcome. You may have a particular style that you like. Doesn't matter. These are just some examples of the different kinds of approaches that are taken in negotiation. It doesn't matter. You have to act with integrity and satisfy yourself that what you're doing for your client not only is in your client's best interest, is fair, reasonable, and results in a positive reflection on you and the rest of us in the profession. Is lying permitted? Is it mandated in order to act as a champion for the client? So there's the example, right? Client will accept nothing less, an opening position, and so forth. Is it possible to lie by omission? Okay, so hands up. You're negotiating. You're trying to get a good result for your client. You have instructions. Can you lie to the other side? Hands up. It's all part of it. Hands up. Nope. Can't do it. Well, according to the rules, right? Okay, what's lying? What's lying? What's deception?
Manipulation.
What's manipulation? Intention to deceive? How do you prove intention? So you can see, right? You're trying to get a good result for your client. You have instructions to do something. How are you going to get there? How are you going to get there? What's the answer? I don't know. I don't know what the answer is. The answer is think about it. Think about it. How do you go in? I would say that generally speaking, when you're negotiating an outcome, chances are you might start a little bit higher than you plan to settle on. I mean, maybe you do. But maybe you don't go in and say, my client will not take a penny less than $150,000. Maybe you say, I think $150,000 is fair. Let's talk. I mean, you have to, anyway, good luck. Right? Good luck. It's a balancing act. It's negotiation. And this is where that notion of your reputation comes in, because in some cases, it's the same counsel over and over again, right? Because if you're working in a particular area, there might be a bar of people that work in that area, so you're going to see each other over and over again. The phone rings and you say, oh my God, it's that jerkhead over there. This is going to be a nightmare. So you have to judge for yourself. So I can tell you. Good luck with that. Is saying $150,000 as an opening position, is that lying? Maybe it's not. Stretching the truth. Difference between outright lying and bluffing or exaggeration. What does that mean? I don't know. Lying is more than stating something is true or false when it isn't. It goes to mislead. Can you lie by omission? Yes, you can. Hands up. Sure you can. What do you think?
Yes, if you omit to miss out some very important facts on intention, then that is lying by omission.
What if your client gives you those instructions? What if your client, you're next. What if your client says, yeah, go in there, I want $150,000, and tell them I'm leaving the country in 2 weeks and I need to know before, and put some pressure on. What do you say?
I think that would be fair to one extent.
But the client isn't. The client isn't actually leaving in 2 weeks.
So, but should I be? Okay, it's an ethical issue.
Yeah, it is. Kasim?
So basically, I don't think that's lying, because you're acting on behalf of your client. And it's subjective.
Hands up. My client is going on vacation in 2 weeks. Better settle this thing because they'll be out of country. I can't get instructions. Your client isn't doing that. You tell the lawyer. Is that okay? Hands up. It's okay. Why?
Sorry, was it me? Me or?
So who put their hand up? Oh, you did.
We both did.
You both did. Okay, now you're first, then Delphine. Why is that okay?
I feel like people do that almost every day at the office. Somebody calls that they don't want to talk to. Sorry, I'm out to lunch.
Okay.
And they don't answer the phone. If you're doing that every day, it's not bad.
Okay, Delphine.
I guess if the lawyer tells the client not to reveal if it's actually true or not, I mean, it's...
Okay. Anybody else? Client's going out. Ikra.
I would say it depends on the result, right? Like, what is your lie going to lead to? If this is just going to lead to like a faster settlement, I don't really see a problem with that.
somewhere, or if the next week you're at a coffee shop with your client and the lawyer comes and says, hey, I thought you were gonna be in France, kind of thing. How does that reflect on you? So it's a question. There's no easy answer, right? Line by omission. So maybe not. Maybe not. All right, how are we doing? Oh my goodness, look at the time. Okay, take a break.
Somebody, for example, omitted by silence.
Can you plead that? Yeah.
So,
Versus regular. And so this is page 469 of the text. Oh, and PEI. Oh, sorry. Newfoundland PEI. And so Mr. Regular, in response to an inquiry about a company, he says, no, company's not being sold. No, it's not being sold. However, that was wrong. Some would say he lied. And the company was substantially sold. And he said, well, that's a matter of opinion, and my client told me not to let the minority shareholder know of the sale. So we have this situation where your client is telling you to do something. And remember we talked about the rule where sometimes having a very frank discussion with your client isn't necessarily rudeness. It might be necessary. So he says, no, my client told me. And the Law Society found his actions to be without integrity. They're rule 2, blown out of the water, totally shot to hell, right? No integrity, it's a whole rule unto itself. And failing in his responsibilities to fellow lawyers, and he failed to avoid questionable conduct. So in that particular case, the Law Society said, well, it's pretty obvious. You said the company not being sold, as opposed to it already had been substantially sold. Like, what if the facts were that the sale was imminent but hadn't closed yet, or there were discussions but hadn't crystallized? It's a continuum, right? When are you lying and when have you crossed the line? In this case, the Law Society said, nope, that was unethical. Mediation, okay. We know encouragement, parties are encouraged to settle. We just saw that, right? Point 2-4, I think. In some jurisdictions, I believe in Ontario, there's mandatory case management, mandatory mediation. I think in family law it's mandatory as well. So it just depends. Trying to come to a solution. Arbitration is a binding result. Mediation is not binding. And it has to be clear that the lawyer who's conducting the mediation will be acting as a third party, not as a lawyer for either party. Therefore, no privilege triggers. And some lawyers do nothing but they have ADR chambers. They have ADR chambers, and that's all they do in terms of their work. Law Society of Alberta has its own rules. Can't lie to the lawyer. So those rules apply in that province along the same notions of integrity and not lying. In the context of mediation, you have a written agreement with terms, rights, expenses, and the mediator cannot be compelled as a witness because they are a third party trying to get the two parties to come to an agreement, so that person is exempt from or taken out of the litigation between the parties subsequently. Benefits. Well, obviously, right? Less challenging emotionally, fewer costs, less time, and you can structure a solution like I said. Any settlement, any good settlement means no one's truly happy because you both give and take on your positions. And here are all of the rules that apply to you as a mediator. So remember the model. The Canadian Bar Association Code of Conduct is optional. The Law Society rules of professional conduct are mandatory, or whatever province, provincial jurisdiction applies. And there's a code of conduct just for mediators. And what is our model code? 5.7-1. It's pretty straightforward. So, lawyer acts as mediator must, mandatory, at the outset of Society of Ontario has rules along the same lines for lawyer mediators. And yeah, 5.7 dash one. Yeah, seek independent legal advice. If there's a draft contract, it should expressly advise and encourage ILA, independent legal advice, unless the people already have representation during mediation. Right? Makes sense. Oh, confidentiality in mediation. This is the Ontario Rules of Civil Procedure. So this is the rule that governs civil procedure, and mediation is confidential. That's the Ontario context. And you're required to communicate, negotiate in good faith, identify interests to one another, assess the risks, and resolve voluntarily. And so here's all the good reasons why mediation is encouraged: self-determination, independence, confidentiality, quality of process. Other principles. Stop me if you have any questions. I think this is all pretty self-evident. And of course, lawyers being lawyers, they always can see two sides of a situation. So there's some critiques, there's some criticisms of mediation. It's unlikely to identify a right or wrong course of action. But some would say, yeah, but that's the whole point, right? You're meeting in the middle somewhere. We're not assigning you're right, you're wrong, you win, you lose. The code focuses on the start of the process. Mediators may choose to direct, facilitate, or suggest depending on the context. There's a power relationship between the parties, internal goals of the process, and other considerations are paramount. So the criticism is, well, it's more process-oriented as opposed to client or client interest-oriented, but the counter to that is the clients have representation usually, and the mediator is just working to bring the parties together. Is this in your book or not? Juice? I don't think it is. I don't know if Pedro has a suggestion. Yes, no, anybody? Law Society of Canada. It is? It'll go, yeah, I've got my book. You mind, hang on? I'll tell you. Law Society, read Juice. Did it make it Law Society of Canada? Okay, FYI then. During the course of the mediation, Mr. Juice, Mr. Juice, failed to be courteous, failed to be civil. He attempts to negotiate directly with a represented person. Once the other side of your situation or your action has counsel, it's inappropriate for you to speak to the person directly. You have to go through counsel. Accused of being offensive and abusive, and actually, I remember this case now. Actually, if you read it, he swears off at the mediator, so last night was not too happy. So it's just an example of mediation and improper conduct. And we've seen this, and we can talk about Michael Clayton. Who's seen Michael Clayton movie? Corporate lawyer, cars blow up, murder. Good stuff. Okay. We can talk about it.
What's the name of the movie?
Michael Clayton. Michael? See, at the end of this class, and you finish your exam, you can watch all the shows.
Have all the time in the world.
All the time in the world. Okay, good. All right, so, okay. So let's talk about, so that's the content of the course. Let's talk about the assignment, which is today's your lucky, lucky day. So today's a happy day. So, before I show you the assignment, which I will post on Moodle when I get back to my desk, okay, we have to set up, we have to organize, we have to get organized. So, reminder, two groups. So for the first group, this is the first group, right? L-O-2, that's this group. If your name falls within there, you will need to pick a 10-minute partner. You will need a 10-minute partner. You need a 10-minute partner, and after those 10 minutes, you're not going to talk to each other ever again, unless you want to have coffee. I don't care. You and your partner are going. Okay, so let's talk about this. And then the same here, same with this group. So if your last day, and I tried to, I don't know if I did an exact halfway division. I mean, I think I did, but I think it's teaching how to study. Same thing. So figure out where you are, and within that group, because you have to come at the same time, you're gonna have a 10-minute break. And here's why. Here's why.
So,
Right?
these are according to the first name, the last name? Last.
Last name. And if someone's stuck with that partner, come and let me know. But I think it's more or less. So in your
Are you the first or?
in your
Should we choose a partner right now?
no, what you're going to do is you're going to choose a partner within your last name group, and you're going to email me your choosing. So I just find out. Okay? And here's why. Here's why. Oh, it's so fun. This is so fun. Here's why. This is the assignment. So first of all, assignment is due Sunday, November 10th. So that's the Sunday before our class on Tuesday. Because anytime to read, like, I'm not a superhero. So you have to submit it online. Okay? You and one other student will be opposing counsel. That's why I need a partner. One is an appellant, one is a respondent. You will only be assessed on your own work. That's why it's a 10-minute partner. After 10 minutes, you're on your own. So I'm not going to assess you as a group. I just need to know, because you need to be paired to argue two sides. So that's the only reason you need to be paired. I'll put this online. You don't have to wait.
So where do we find somebody to be in our?
Yeah, there's a list. Online, there's a list. Or you can look here. You can stay after class and do it now. I don't care. I don't care. Okay? Just figure it out. So you need a partner. So after 10 minutes, you're done. So you're only assessed on your own work. I don't care what your partner does. I'm just focusing on taking a Brown approach for your assignment. Okay. Together, the only thing you'll do, which takes 10 minutes, is find your partner. Is you're going to choose a case. And you can choose a case in our text. It can be a case that we highlighted in class, or it can be a case that we didn't highlight. I don't care. Choose what you want. It's your choice. That is, the two of you together have to choose. Because you're going to choose a case discussed in class or not, but it has to be from here. You can't, go out and look on Lexis. So it has to be. And what you're going to do is you will decide as your partners for 10 minutes. One of you will be appellate, and you are going to appeal whatever decision you pick. Okay. The other person will be a respondent who says, no, don't let the appeal go ahead. The decision was correctly decided. So and after those 10 minutes, pick your partner, pick your case, pick who's appellant, who's respondent, and then email me so I know who's who. You are not to work together otherwise. You cannot work together otherwise once you've decided those three things: partner, case, and role. So you're going to appeal whatever you decide. You're going to appeal that decision to a single justice of the Supreme Court of Connecticut, and that is a court to which you can even appeal a Supreme Court of Canada case. So if you pick a Supreme Court of Canada case, no problem. I have jurisdiction here. So you're going to pick that case, you're going to appeal it. Or if it's not Supreme Court, I don't care. I'm just saying, it's not like there's no limit. You can appeal it. You're going to write a summary, 500 words in length. So very concise. You're going to write a very concise summary of your key points, and then that's what you submit online. There's a form I'll show you. By November 10th, late submissions will be subject to deduction. So if it's 2 2 a.m. on the 11th, that's too late. You have a certain period of time to do it. That's part of the exercise, is a time constraint. Okay. There's a form. Here's the form. This will all be online. Here's the form. I don't want to make it too small. So you're going to name whoever is the appellant, whoever is the respondent, give me the case you're actually talking about, and I'll have two forms, right? One will be the key points of whatever your name is in your counsel for appellant, and there'll be a corresponding one for counsel for respondent, right? And here's your form, and you can populate it. Okay. So, on the form, couple of rules about the written submissions. Number 1, keep the word count. Give me the word count. Do a word count? Show it to me. I don't want 750 words. That's not the assignment. The assignment is 500. I don't want 700. Include the word count. After you've given me you pick a case, A versus B. Supreme Court of Canada, I don't care. You decide you're appellant. Here's why that decision should be overturned. Now I'm appealing it, right? After you give me your submissions in that form, word count, at the end, not part of the word count, at the end you're going to think of a question. Think of a question for me to ask your opponent. So that will force you to understand your opponent's side of the argument. You have to anticipate what they're going to say as respondent or appellant, like both have to do it. And it has to be a challenging question. So you have to know the weaknesses in their case. So not only do you have to know your case and argue why the appeal should go ahead or not, you have to know the side's case and where their weaknesses and what question. Don't tell them the question. That's your surprise on the 12th. So if you two are partners in each other's cases, and at the end of your submissions, you say you with that question. Pardon? You never know what the judge's going to ask you. There's your surprise. You're never going to know what the judge, how they hear it, what they think, what they understand, and if they could be out left field, doesn't matter. So there's no element of surprise in exchange of documents and arguments, because you'll get the written version and so on, but you never know what the judge is going to say. Okay? Fair enough, but except for the judge. Wild card. So don't give me a question that says, do you agree that Rule 5 of the Model Code applies? Like, that does not challenge the other side's position, right? You want to find a weakness. You want the judge to say, oh yeah, what about this? And that person has to think on the key answer, right? Okay. A specific point or weakness in their position, do not tell your partner, your 10-minute partner. So then you've got your oral submissions, you'll come to class on the 12th and you'll make, you've got your written submissions, you'll come to class on the 12th and you'll make oral submissions on the basis of your written submissions. And you'll have 6 minutes, there'll be a timer. Why 6 minutes? I'll post it. Don't post it. Why 6 minutes? 6 minutes.
That's the usual.
6 minutes is the increment for billing, right? When you bill, you bill it in 6-minute increments. Plus, we have a class that's so big I can't do 10 minutes. So that's a time limitation. And here's the point. The point of this exercise is I want you to show me your understanding and application of the model. So that means that when you're writing your submissions, when you're making your oral submissions, when you're answering the question, the point is not to know the facts of the case that you're appealing. The point, because I read the case, the point is not to show what a good litigator you are and waving your hands in the air. The point is to tell me which relevant model code sections and commentaries are applicable to the position you're taking on this appeal. Okay? We have relaxed rules of evidence, and you can refer to any commentary or anything in the model code that you say is relevant even if it's not in the decision. So you're not bound or limited by what the decision only talks about Rule 2, for example. You're not limited by that. And make reference to anything that's and yeah, even if it's not part of the decision. You can you can cite other case law, no extra research. You're really just focusing on pick your case, develop your argument, develop your position, be prepared to understand the other side's position, and reference them all. This is not, don't give me like a memo. Okay, so time limits. So even though your written submissions might have, I don't know, 2 points, 3 main points, 3 key points, whatever, because you only have 6 minutes to make your arguments, prioritize, choose your best arguments and go. But, because you know what? If you have 3 good arguments and 2 crappy ones, if you don't win on the 3 good ones, you're not going to win on 2 crappy ones. So just focus and prioritize. Right.
Is the 6 minutes including time and question?
No. So that's why we have, it's not going to be. No, but the answer to the question shouldn't take more than 30 seconds, right? Because you should anticipate what your weaknesses are and what they're going to ask you, so you should, be thinking about that. Okay. And the 500-word limit is for your submissions. Don't count the question. Okay, the question's free words. But don't give me a question like this. Okay, so those are your rules. I'll post that, and this is your form. Please fill it out. Please fill it out. Put your name on it, and put your opponent or your partner's name on it. Put the case down, because I get things that are blank. But it's not. Okay, and then your question comes down here for the other side. That's the assignment. You know what to do. You can spend a few minutes after class. Does anybody want to talk about the exam or not? I'm here. We have a few minutes. Yes, no? Yeah.
The only thing that is model code, is that correct?
Your preparation for Julia. Yes. Within reason. And I've had this question, I always have this question. So it has to be reasonable, right? You can tab it, yeah, I think you can. I highlight mine, I make little notes. But you can't use like this blank page. You can't use this and cover it in text. You can't do .2 font and write in all your notes, or just be reasonable. If you have keywords or key triggers for cases or whatever, that's fine, a few, but you're not going to look at, the invigilator's not going to let you have that. So that's what I do. Right? Circle, highlight, asterisk, triggers.
Sorry, can we write cases on the side?
I think you can, like in the margins. I think you can. Remember though, some of your commentaries have cases. It's like they're already there. Don't waste your ink. Okay, so you can, so that's right. So you can have a look at your exam, yes, no, interesting. Yeah. You know what? I haven't finalized it yet, but it's going to be like 3, maybe, little subsections, maybe. So the exam. Okay, so the exam is, I think, 3 hours? 3, December 13th. Lucky 13th. 3 hours. You must answer all questions, but we know choices. You can't say I want this or not. No, just everything. And I think it's 16. And I can tell you, what I can tell you is there'll be fact scenarios. Blah, blah, blah does this, and blah, blah, blah does that. Question. And so, what's IRAC? Does anybody use IRAC?
Yeah.
When I was in law school, we called it PIRAC. The first thing you do is panic. And then you do everything else. So what you want to do is you want to identify the issue. What's the problem in this little, and the fact scenarios are not 4 pages, right? It's like a paragraph or 2. Here's what's happening. Identify the issues, right? What's R again? Rules. That would be case law. So for the exam, case law and rules. And don't forget to read the Trevor Farrow, or reread the Trevor Farrow article. Analysis and conclusion. I don't care what your conclusion is.
之前告诉他。但是我不知道他的时间就是几个时间。刚说他有招呀，不跟你说，然后不说以后不说词说的。
Oh, yeah, we just.
Yeah, I don't have one yet. I am the second group A to
Me too.
LI.
Okay.
Yeah. Sorry,
然后，而且队友他都不给，然后完了或者到那边去帮他们然后，对他们就是连不起来。
Have you been doing readings mostly?
Yeah. 他就说他们
Yeah.
反正我们
Except for
衣服的好。
2 years. For the most part.
Do you want it like decide now or?
No, we can look through it and see what sort of works. There's no point us picking a case where we're not going to have good points in either direction.
Exactly. Okay. So do you want to get my number? We'll
Yeah,
switch
sure.
numbers.
Yeah, no worries.
'What's your name?
I go by Vic, but it's Victor Long.
And later on in the day, we can just take a picture.
Yeah.
Yeah. Oh, we need to email them.
Yeah, I took a note real quick when she was speaking about her saying she drop an email to let her know.
Oh, yeah. Okay. Perfect. Okay, great. Thanks.
You want to just double check to see if
Oh,
you,
yeah.
Cool? Okay. Stop only.
Does anyone still need a partner? Need a partner?
Good manage.
我们就自动成为一组了吗？我们两个都没有商量。
放过彼此吧，我。
没有，咱们可以这样相互。对呀，就是把全部都写下来，这样我们就能